Okay,
Here we're gonna go on.
this is a copy of what we went over in the jail
Shirts
today.
first.
Okay.
Shirts is
The amended information and a statement from the girls'
number
mom.
7 on the docket.
Thank you. And I'm looking at an amended information charging one count of assault in the second degree domestic violence. Mr. Schertz, did you get a copy of that? Okay. How old are you, sir?
18.
How far did you get in school?
To 10th grade.
Do you read and write English?
Yes.
Were you able to read, go over, and understand the guilty plea statement with your attorney's help?
Yes.
Do you need any additional time with him or questions of him before we go forward today?
Yes, sir.
And you understand the amended information is the charge that you're going forward to plead guilty on? Do you need extra time to go over that with Mr. Bear?
No, sir.
Okay, you have the following rights: the right to a speedy and public jury trial, the right to remain silent, the right to hear and confront the witnesses against you, the right to call your own witnesses, even if that's at public expense, the right to the presumption of innocence, and the right to appeal if you were found guilty at trial. Do you understand all those rights?
Yes, sir.
And you understand those are what you're giving up to plead guilty today? Okay, if you're not a U.S. citizen, a guilty plea could affect your status in this country now and in the future. Counsel, without asking you to disclose your client's status, do you need time to cover those issues with him?
No, Your Honor, thank you.
Okay, if you're on probation, parole, or supervision for a different crime, a plea of guilty in this case could affect those cases. You could be required to pay costs, fees, and assessments, including Crime Victims Compensation Fund, domestic violence evaluation and fees, restitution up to twice the amount of the victim's loss, if that applies. Since there's a felony here, you'll be required to give a DNA sample and charge the collection cost of that. And also, from here on out, it is now illegal for you to use, own, or possess any firearms until you get those rights restored. Do you understand all that?
Yes, sir.
To the extent that you're incarcerated, you won't be eligible for any public assistance. The charge here, assault in the second degree, domestic violence, that is a Class B felony, isn't it?
It is, and
Yes, Your Honor.
that should say 10 years, $20,000.
That's
Thank
kind
you.
of what I was thinking. So we'll change that on page 2 under paragraph 6. So is there agreement as to the scoring? 4 points?
From our perspective,
I'm just double checking it, Your Honor. It's like.
well, wait a second, wait a
Mr.
second.
Farah has it at 2 points. And that seems to make sense based on what I'm seeing. I see an assault 4 that gets scored as a point, a violation, no contact order, domestic violence that gets scored as a point, unlawful imprisonment that's a half point, so with a 2.5, it's an offender score of 2. That's what we see.
Yes, that is absolutely right. We did adjust that, and thank you for catching it.
Does that change the standards then?
No, no,
No, it's a
that's how
12.
we got to 12 to
Right,
14.
it's 12 plus to 14 months on an offender score of 2.
All right, thank you. So I've made that correction. 2 points appears to be the appropriate number. For purposes of calculating your standard range, sir, that would be 12 plus to 14 months in in prison, with 18 months community custody, maximum 10 years in prison, maximum fine $20,000. Do you understand that's what you're potentially facing by pleading guilty today?
Yes, sir.
And even though there may be a sentencing recommendation that you bargained for as part of this process, it's only a recommendation. The court gets the last word on that, and the court can go above or below the recommendation. So there's no guarantee. You understand that? Other than that recommendation, has anybody promised you anything or threatened you in any way to get you to change your plea to guilty?
No.
Well, then do you plead? And you gave a statement in support of that says, on or about December 6, 2014, in Clark County, Washington, you did intentionally assault Shane Perkins, a family or household member, with a knife. Is that your statement, sir?
I do not remember saying that.
That's a statement under paragraph 11. On or about December 6, 2014, in Clark County, Washington. Do you agree with the date and the place? You did intentionally assault Shane Perkins, a family or household member, with a knife. Do you agree with that?
Yes.
So it's true. It's all true and correct? Okay, in that case, we'll accept the guilty plea as factually supporting that charge, assault second-degree domestic violence. And that it's freely and voluntarily given, knowing and intelligent. State's recommendation.
No, it's a year-and-a-day recommendation on that range. This was the same victim as he had on the previous assault for domestic violence, and the sentencing range is 12 plus 24 months, or sorry, 14 months. This is an agreed recommendation. It's a 10-year no-contact order with the victim, 18 months community custody, DV treatment, and the defendant is also, as part of this agreement, he's agreed to plead guilty in district court to a domestic violence no-contact order, which is a gross misdemeanor. That's not before us here today, but that is part of the overall agreement. I'm assuming Mr. Farrer is probably handling that as well. So, given all that, we just ask you to follow the agreement of 366 days.
Credit for time served calculation?
Oh, I'm sorry, Your Honor. He has 50. I think it's 50 something. It didn't write that down for me. 52 days.
All right, Mr. Barrett.
Your Honor, I think I would like to respond to the statement of the victim's mother in this case, because I think it is very compelling and it's very impassioned on her part that she is very frustrated.
And for the record, I was provided with a copy of that. I did review it, and it's been requested that instead of her personal appearance today, that the statement be filed with the clerk of the court.
Your Honor, I guess I'll make very clear too that that was the intent that we got from the victim advocate and the DV unit, that originally we were thinking the victim might attend, and I'm assuming that in this case Shane is not yet, and then whatever happened, she's not attending, but we are okay with using the victim in her stead, or the mother's statement in her stead. So.
And obviously, Mr. Barrett, you had a chance to look at that and wish now to respond to. So.
And we just want to make sure that statement gets into the court record.
Thank you.
I do, Your Honor, because I think it's a compelling statement by the mother who's frustrated that her 16-year-old daughter and 18-year-old Darren do not stay apart when they are clearly not well together and they do not behave together. There is a history of misdemeanor assaults and no contact orders, and I think she is very, very frustrated with all of their behavior. This is a situation where they were together on the night in question in violation of a no contact order, which we will plead to in district court. There was an attempt by her to express her displeasure with what he was saying, and he was intent on her listening to it. Another group of individuals came to her aid, at which point he felt threatened. He pulled out a knife. At some point, there was, I think she was attempting, and I think the evidence will show that she got sliced by the knife right here on between the web of her thumb and her forefinger, which would be in our position consistent with trying to get the knife out of his hand to stop him from doing something stupid. He indicates, and he has already, that he was highly intoxicated. He's 18 years old. He shouldn't have been drinking. I think the victim, I think it's safe to say the victim in this case was not cooperative, but that doesn't mean that the state should not have gone forward. Mr. Farrer and I reached this resolution in considering all that, and I respect the mother's position, and as a parent, I totally understand it. Mr. Schertz is 18 years old. He's going to go to prison. He has a significant criminal history now. Any further foolishness on his part is going to result in substantial time. We would ask the court to follow the bargain for recommendation of a year and a day. I think it's made a great impression on him. He is very grateful that he is not facing a trial where he's looking at upwards of 60 months with the weapons enhancement. He has gotten a major benefit, and I think I know that I have spoken to him at great length about what he's getting and the opportunity he's getting in this offer, and that he had better take advantage of it, or else his future's not going to be very bright. And I think the mother's letter to the court drives that point home. I provided him with that copy, so in case he forgets about it, he can read it someday. We'd ask you to follow the recommendation.
Thank you, Mr. Schertz. You have the right to make your right of allocution to make a statement to the court before sentencing. Is there anything you wish to say?
Not that I can think of, sir.
All right. When do you turn 19?
October 9th.
October?
Yes.
All right. Well, the court reviewed the probable cause statement, reviewed the victim impact statement, and this is fairly shocking. It's always sad to see somebody at the age of 18 start out of the gates and have something like this happen. I usually give that a little more weight towards the side of some leniency, but since this is not the first incident, because there was a no contact order in place, to me that's more troublesome. I'm going to sentence to 13 months under the circumstances. credit for the time served, other standard costs, fines, and fees. I'm going to sign a no-contact order, sir, and, to the extent it hasn't gotten through before about no contact, this is very, very serious. Given the history here, there's just absolutely no wiggle room in any way, shape, or form with respect to this no-contact order. You are prohibited, and you'll get a copy of this, from any contact with Shane Perkins. That's direct, indirect, through third parties, electronic, you name it. Any sort of contact like that, even if she initiates it, you're the one with the no-contact order, and that will be taken, I'm sure, very seriously by the prosecutor's office. It'll certainly be taken very seriously by the court if it ever comes back in front of me. Are we clear?
Yes, sir.
Okay.
Thank you, Your Honor.
I didn't see any on the memo. Is there any indicated on that?
Restitution? No.
I think it's to be determined.
To be set.
Doing Williams next. And Williams is number 8. Proceeding on the original information.
Okay, so you're Vincent Lamar Williams,
Yes, sir.
and this is on the original information?
It is, Your Honor.
Pleading as charged, okay. Mr. Williams, how old are you?
I'm 20.
How far did you get in school?
Graduated.
You read and
High
write
school.
English.
Yes, sir.
Were you able to read and go over and understand the guilty plea statement with your attorney's help?
Yes, sir.
Do you need any additional time with him or have any questions of him then before we go forward today?
No, sir.
Okay, you have the following rights: the right to a speedy and public trial, the right to remain silent, the right to hear and confront the witnesses who testify against you, the right to call your own witnesses, even if at public expense, the right to the presumption of innocence, which means the state has the burden to prove you guilty beyond reasonable doubt, and the right to appeal if you were found guilty at trial. Do you understand all those rights?
Yes, sir.
And you realize those are what you're giving up in order to plead guilty and get the benefit of whatever sentencing recommendation may be coming.
Yes, sir.
If you're not an American citizen, then a guilty plea can affect your status in this country, now and in the future. Counsel, without asking you to disclose your client's status, do you need time to cover those issues?
No, Your Honor.
If you have, if you're on probation, parole, or supervision for a different crime, a plea of guilty in this case could affect those cases. You could be required to pay costs, fees, and assessments, including Crime Victims Compensation Fund, restitution up to twice the amount of the victim's loss, etc. Because this is a Class B felony, you'll be required to give a DNA sample and charge the cost of collecting that. You'll be giving up your voting rights unless and until you get those restored, and your rights to use, own, or possess any firearms unless and until you get those rights restored. And if you're in custody, you won't be eligible for any public assistance while you're in custody. You understand all that, sir?
Yes, sir.
Turning to the specific charge here, robbery in the second degree, as mentioned, that's a Class B felony. There's no criminal history for scoring, apparently. Standard range then 3 to 9 months on this charge with 12 months community custody, maximum 10 years in prison, maximum fine $20,000. You understand that's what you're potentially facing by pleading guilty.
Yes, sir.
And even though there may be a recommendation that's coming, it's only a recommendation. It's not a guarantee of what your sentence will be. That's the court that decides. So it could be higher or lower than what's being recommended. You understand that?
Yes, sir.
Other than that recommendation, has anybody promised you anything or threatened you in any way to get you to plead guilty?
No, sir.
Then do you plead on these charges?
Guilty.
Your statement says that between December 14, 2014, there's a typo there, so I'm going to change that back to December 14, 2014, and December 15, 2014 in Clark County, Washington, with intent to commit theft, you did unlawfully take personal property, to wit, U.S. currency, from the person, to wit, Jianqi Zhu, against said person's will, by the use or threatened use of immediate force to said person. Is that your statement, sir?
Yes.
Is it true and correct?
Yes, sir.
The case will accept your guilty plea. State's recommendation.
Yes, Your Honor, this is a case of just to add a little more context to the somewhat sterile statement of plea of guilty. This is a case where the defendant and his co-defendant posted an ad for escort services. The victim responded to that ad and met the co-defendant in the hotel room. Co-defendant asked for $200 once the victim gave her the money. Co-defendant then said that the victim needed to leave because her boyfriend was coming and he was a really violent person. The victim refused he wanted his $200 back. Then defendant came out of the hotel room bathroom and threatened victim, pushed the victim out of the door and slammed the door on his foot. Co-defendant and the defendant kept the victim's $200. And later the defendant did admit to participating in this scheme around 25 times prior. So anyway, this is his first felony that we know about. It's an offender score of 0, 3 to 9 months. So hopefully this will never happen again, but it's a 3-month jail recommendation. He has 44 days credit. So if Your Honor followed the recommendation, he would have 46 left to serve. There's 12 months community custody because it's not a DOC sentence. If he had been up in that range, it would have been another 18-month community custody. But 12 months community custody, the victim has been notified, and given this type of case, we were not expecting the victim to attend. He did not intend to go into. That was a challenge to do. And that's a 10-year no contact. It's part of the judgment and sentence. It's not part of any separate order, but it would be 10 years no contact with that person, whether he knows him or not. And that's it, Your Honor.
Just for clarification, do you have him being arrested on December 14th? Because I have 45 days. You said 44.
I have him booked into the jail on December 15th.
15th. Okay, that's
Probably
44
a.m.
days.
That's my guess.
Yes, Your Honor. As you can see, my client is only 20 years old. He has no prior felonies. I am not condoning what he did, but just so that the record is clear, is that the victim didn't have extremely clean hands either. He came there, and he indicates to the police officer he came there for the purpose of purchasing sex. So, again, my client realizes what he did is wrong. Hopefully, this is not going to occur again. We would just ask the court to follow the state's recommendation.
Mr. Williams, any statement you wish to make to the court before sentencing?
I know what I have done was wrong, and all I can say, I will never do it again. My actions can prove it more than my words.
Anything else?
No, sir.
All right. Well, the court is concerned. I appreciate the argument of defense counsel. However, the way market economics work is, if it weren't for supply, then it's a question of whether there would be demand or not. So the existence of demand by itself does not gain a lot of traction on the supply side of the equation, in this court's opinion. Under the circumstances, the court is concerned that this kind of crime in the community is not particularly helpful. It invites property crime, but could also invite something worse where somebody could get hurt. The court's going to sentence to 4 months under the circumstances, with the credit for the time served, standard cost, fines, and fees.
Thank you, Your Honor. We have to step over here to sign some documents. Here's this yours.
Your Honor, so I see that as 74 days remaining. And it'd be 120 days. Oops, so that's actually, it's 44.
So when you get out, 24 hours.
I'm sorry, Your Honor, that's not right. I did the math wrong. It's actually going to be, it's 44 days credit, so that would actually be 76 days remaining, not 74, 76
That's correct.
days.
I'm making that change on the third page.
Thank you. I do have it correct on the memo.
Mr. Williams, do you have a job? How do you support yourself? Any reason? Pardon? Okay. All right, I'm going to find that he has ability to pay the financial portion of this judgment and sentence, and you'll have to be in touch with collections office to get this paid off, either in one payment or over a series of payments. They'll work with you, but it's up to you to get in touch with them and make sure it gets done, right?
There was a set restitution amount of that $200 as well, Your Honor. Mr. Weir, we're going to do Davis next. Did I sign your statement of plead guilty on
You
that?
did. You didn't sign the criminal history, so I
Okay.
can give you that.
Your Honor, it's going to be number 5, J. Kenyon Davis, number 5. Davis? Got it. Does he need to sign, Mr. Weir?
No, he signed.
All right, Jerry, are you Jay Davis?
Yes, sir.
How old are you, sir?
31.
How far did you get in school?
Ninth grade.
Do you read and write English?
Yes, sir.
Were you
Not very well, Your Honor. To be perfectly honest, he doesn't track too well.
Understood. Were you able to read and go over and understand, with Mr. Weir's help, this guilty plea statement?
Yes, sir.
Do you need any additional time with him or have any questions of him then before we go forward today?
No, sir.
Okay? If at any point in these proceedings you're not understanding what's going on, would you please stop me and ask me to explain?
Yes, sir.
Okay. You have the following rights: the right to a speedy and public jury trial, the right to remain silent, the right to hear the witnesses against you and confront them, the right to call your own witnesses, even if that's at public expense, the right to the presumption of innocence, which means the state has the burden to prove your guilt beyond a reasonable doubt, and if you were found guilty at trial, you'd have the right to appeal. Do you understand all those rights?
Yes, sir.
And those are what you're giving up in order to plead guilty today and get the benefit of the sentencing recommendation. You understand that?
Yes, sir.
Okay, if you're not an American citizen, then a guilty plea could affect your status in this country now and in the future. Mr. Ware, without asking you to disclose your client's status, do you need time to cover that issue with him?
No, Your Honor.
If you are on probation, parole, or supervision for a different crime, a guilty plea in this case could affect those cases. You could be required to pay costs, fees, and assessments as part of this judgment and sentence, including, but not limited to, a drug fund contribution, other fines, etc. Because there's at least one felony here, you'll be required to give a DNA sample and charged the cost of collecting that. You'll be giving up your voting rights unless and until you get those restored, and your rights to use, own, or possess any firearms unless and until you get those restored. You understand all that, sir?
Yes, sir.
All right, the specific charge here, possession of a controlled substance, methamphetamine, that's a Class C felony. There's agreement as to the scoring, 4 points on the history.
Yes, Your Honor.
Yes, Your Honor.
That means that the standard range, sir, here is 6 to 12 months, with 12 months community custody, max 5 years in prison, max $10,000. So that's what you're potentially facing by pleading guilty. You understand that?
Yes, sir.
And even though there may have been a recommendation that you and your attorney in the state have bargained for, the court gets the last word, so there's no guarantee that what they're recommending is what I'm going to sentence you to. You understand that? Could be more, could be less.
Yes, sir.
Other than that recommendation, has anybody promised you anything or threatened you in any way to get you to plead guilty?
No, sir.
How then do you plead to this charge?
Guilty.
And you were asked to give a statement, and your statement says that in Clark County, Washington, on November 3, 2014, you admit that you unlawfully possessed the controlled substance methamphetamine. Is that a true and factually correct statement?
Yes, sir.
In that case, you'll accept your guilty plea. State's recommendation?
Your Honor, it's 181 days. It's a range of 181, 6 plus to 12 months. 12 months community custody, standard fines, fees, conditions, and treatment if needed. He has 85 days credit, so if Your Honor followed the recommendation, he would have 96 days left. So 96 left to serve and 12 months community custody, and that is all.
Your Honor, as I indicated earlier, Mr. Davis has had some learning problems. I think he's would like to say that he's capable of reading and writing, but I think he's qualified, in my view, for Social Security disability. And you're in the process of applying for that, are you not?
Yes, sir.
The amount of drugs involved was pretty minimal here. This is a situation where Mr. Davis was seen riding his bicycle, the allegation being that he didn't have a helmet on. He was stopped on that basis. He was searched based on the outstanding warrant, and a small amount of methamphetamine was found as a result. I think that he was trying to get into drug court, and drug court didn't take him for reasons that I'm still puzzling over, but I guess it's their standards. He has some mental health issues, as do most of the people in the Clark County Jail, or at least a substantial number of them. But he needs treatment and wasn't able to get it through drug court. So I think the recommendation under those circumstances is an appropriate one. I would ask the court's consideration of eliminating some of the discretionary cause involved here. He simply hasn't had any work history to speak of, and as I say, is considerably disabled and has a mental health issue as well.
Hey, Mr. Davis, any statement you wish to make to the court? All right, thank you then. Was it 6 to 9 months or 6 to 12 months?
6 plus to 12.
6 plus to 12, so it's, the history adds up. How old are you again?
31.
31. Yeah, it's a pretty stiff sentence, but that's what the law calls out for, and I'm not really in a position to make my own determinations on that, so I will follow the recommendation, the 181, credit for the time served.
We agree with the 85.
Agree with the what?
85 credit.
That leave 96 to serve.
All right, I will find that he is presently indigent and does not appear to have future ability to pay.
Thank you, Your Honor.
And also, I will strike some of the discretionary items. I'm going to strike the court-appointed attorney amount. I'm going to strike the fine. The drug fund contribution, I think, is still going to stay. That's a $2,000, unfortunately, probably his second or third.
I don't mean to argue with the court. I think it is discretionary. I don't think it's a
Oh,
mandatory.
with the drug fund, that's statutory. But I don't think it's.
Even if it is discretionary, I'm inclined to keep it. So,
There's a $3,000 drug fund that is.
Here's where you report to probation. You're talking about manufacturing.
Well, there's some other language in there. But anyway, it doesn't apply to straight possession.
Where to go to pay, to make arrangements to pay. This is where you go to
And
report.
Mr. McCanavich, did you need something from the court on Williams?
Appreciate it, Your Honor. Thank you.
Your Honor, Mr. McCanavich wants to be heard on the Williams matter that we just did. What's the?
Do we need Mr. Williams back out? He probably should come back out, Your Honor.
Mr. Williams, come on out for a second.
Your Honor, on the judgment and sentence, I noticed that there was a $200 restitution. That's nowhere in the offer, and as a matter of fact, my client indicated that the police officers took the $200, and if you look on the evidence sheet, there's both $100 bills, so the police officers had the $200, so I don't believe my client needs, I don't know what the officers did with the $200, but that's not, my client shouldn't be responsible for something that the police officers took.
I apologize. I don't have any other information. I can't clarify. I mean,
here's what we'll do. We'll correct it to say to be set, and if in which
and if when he tries to go get his property back,
Yeah.
then it will never even come up.
Okay, I mean, just
That's fine. Just to be set. I'm fine with that.
Yeah, I have no objection to that, Charlie. I
I
just
just
want to
could you do me a favor and maybe just a quick email to Aaron Bartlett too, and just give him a heads up on that.
Okay,
So that when he does the property release, it's clear that that needs to go to the victim.
okay, perfect. I'll do that this afternoon.
thank you for
And I'm
bringing
just
that to our
indicating
attention.
to be set.
He's going to have enough fees and
Having
fines.
you
I want to see it right.
Mr. McCanavich,
Yes.
you want to initial that?
Yeah. So right here, just have to initial right here. Okay. So if you would just initial right there. Right here, just right here. Right there, yeah. Okay, we're good now. Thank you, Your Honor.
Good catch.
Okay, we're going to call Duhamel, Adam Duhamel, and Duhamel.
3 and 6.
3 and 6. on one of the cases, the cause number ending in 021879, we're submitting an amended information. And copies to council on that one.
Your Honor, if I could just pause for a second here.
Certainly.
I am filling in for Ms. Whitney Tay from my office, and I have just spoken to the defendant's mother. She has some concerns about his mental state to proceed and his responsibility for his actions. I'm uncomfortable going forward today with this because of that.
The state's not going to object. I think we have a trial date forward.
Well, we got a trial date next week.
Oh, next week, so we're on for readiness tomorrow.
Well, it's,
Why don't you just come back for readiness tomorrow and
the only other thing, since we have a decent sized readiness docket, I'm wondering is, would you be comfortable, because it seems silly to come back to court tomorrow if we're going to do the same thing, what we could do.
reset trial now?
We could do two things. We could reset trial now and have you go over a speedy trial waiver with it, but then also on the scheduling order, we could set a change of plea date next week so that there's time for everyone to work things out. Either Monday or Wednesday change of plea.
There's not been a continuance in these matters. There are two matters that I can see.
Correct.
I would be comfortable advising Adam to waive his right to speedy trial today, so that we can look into the issues that your mother raised with me now, and see if there's anything that would be beneficial to you. This deal is not going to go away. It's not going to hurt anybody just to take a deep breath, step back, and look at it. Are you okay with that?
I guess.
There you go.
We've got a commencement date of today's date on the 2364-2 case.
Which one do you want to write up, and I'll give you one for you.
I'll do this one, you do that one.
Yes. For each case. Sorry.
So I don't think we need a waiver on that one because we're already at today's date for commencement on the
Oh, because we're-
02364-2
So, Your
case.
Honor, which one do we not need the waiver on?
02364-2.
One new from
That's the one I have.
The other one has commencement date of December 11.
Right, so we'll set that
okay.
trial date, and the other one will still track, and then we'll have a,
What date are you proposing for a new commencement date then?
Would today be all right?
that's fine.
All right, so Department 6 trial dates within speedy. We'll give you, sorry. How about March 9?
That'd be fine, thank you.
March 9 is a 40-day set using today as the commencement date. March 5 at 1:30 will be the readiness hearing on that. And then we'll do the same thing for the other case. It'll be 0 days elapsed, but we'll use the same readiness and trial date if that works. So those two are linked.
44, 49 days left.
From today, what was our trial date? March
9.
40? 40.
I gave you everything back. On, Mr.
Yes, you did, thank you.
And do you want to set a change of plea date next week, Mr. Brad?
I would prefer to cite it.
Okay.
There may be an evaluation done.
Okay.
Just in
Understood.
light of the information. An evaluation requested.
All right, so we're giving you some new trial dates, Mr. Duhamel, out to March 9. But in the meantime, you'll have a chance to talk with your attorney.
And they're each going to have the same trial date at this point, Your Honor?
That's what I'm suggesting. It'll be 0 days elapsed on the other one because of the excluded time on the junior case.
No objection, however, there has been no motion to join them at this time.
And state agrees.
Thank you.
This one, 40 days elapsed. Did we get all that correct? Yes. We don't have the. That's all right. Just figured we have everybody here. Might as well take one more case off.
Thank you. So we'll strike that from tomorrow's
Am I
reading.
writing this tomorrow? Speaking on behalf of those who preside over some pretty heavy readiness dockets, I think we appreciate any active management efforts on
Thank
the
you.
front end. Thank
All right,
you.
we'll be in touch.
I
Thank
try,
you.
Your Honor. Your Honor, next we can do Trevor Smith.
Trevor Smith? Wait, wait, I'll talk to you outside.
So what's this?
Their copies and your stuff.
Oh, right.
Your Honor, this is Trevor Smith, and this matter is prepared to proceed to trial. The state is moving to dismiss all counts except for the bail jump with a Class B or C felony and mid-range
And
recommendation.
the state is handing out the second amended information to that effect.
So that drops those first two, and, okay, got it.
Oh,
All right, so Mr. Smith, did you get a copy of the second amended information, which contains only one count of bail jumping on Class B or C felony?
Yes, I did.
Is it your understanding that's what you're going forward to plead guilty on today?
Yes.
Okay, how old are you, sir?
29.
How far did you get in school?
12 years.
Do you read and write English?
Yes.
Were you able to read and go over and understand the guilty plea statement before signing it with your attorney's help?
Yes, I was.
Do you need any additional time with him or have any questions of him before we go forward today then?
No.
Okay, you have the following important rights: the right to a speedy and public trial by jury, the right to remain silent, the right to hear and confront the witnesses against you, the right to call your own witnesses even if that's at public expense, the right to the presumption of innocence, which means the state has the burden to prove your guilt beyond a reasonable doubt, and the right to appeal if you are found guilty at trial. Do you understand all those rights?
Yes.
Do you understand those are what you're giving up to plead guilty and get the benefit of whatever sentencing recommendation may be coming?
Yes.
Okay, if you're not an American citizen, then a guilty plea can affect your status in this country now and in the future. Counsel, without asking you to disclose your client's status, do you need time to cover those issues with him?
No, thank you, Your Honor.
If you're on probation, parole, or supervision for a different crime, a plea of guilty in this case can affect those cases. You could be required to pay costs, fees, and assessments, including, I don't know if the Crime Victims Compensation Fund applies here for a bail jump, but anyway, standard costs, fees, and fines. Because this is a Class C felony, you'll be required to give a DNA sample and charge the collection cost of that. You'll be giving up your rights to use, own, or possess any firearms until you get those restored, and your rights to vote. To the extent that you're incarcerated, you won't be eligible for any public assistance while you're in custody. You understand all that, sir?
Yes.
And your name is Trevor, Trever Smith?
That's correct.
I'm just going to write that in on front page number 1. It was still blank. So, okay, so turning to the specific charge here, bail jumping on a Class B or C felony. That itself is a Class C felony. There's no criminal history for the court to consider on this then, apparently. Standard range 1 to 3 months on this charge. Maximum term 5 years. Max fine $10,000. You understand that's what you're potentially facing by pleading guilty.
Yes.
And even though there may be a sentencing recommendation that you and your attorney bargained for with the prosecutor, this court gets the last word, so that's no guarantee. I could go above or below that recommendation. You understand that?
Okay. Yes.
Okay. Other than that sentencing recommendation, anybody promised you anything or threatened you in any way to get you to plead guilty?
No.
How do you plead on this charge then?
Guilty.
And you were asked to give a statement. Your statement says that on or about December 18, 2014, in Clark County, state of Washington, you did knowingly fail to appear for a Class B or C felony in which you had signed a promise to appear. Is that your statement, sir?
Yes.
Is it true and accurate?
Yes.
In that case, we'll accept your guilty plea. State's recommendation.
Your Honor, it's 45 days total on that 1 to 3 month range. which
Sorry,
is
how much?
45 days,
45.
so essentially mid-range, which is the presumptive sentence. You'd have 38 days credit, so you'd have 7 days remaining. There's no community custody. The other charges were obviously dropped off. We're only proceeding with bail jump. And standard fines, fees, conditions, and the victim in this case was unreachable. We did try to reach the victim, made efforts to do that, so we do want to proceed. That's all.
Counsel, did you count the when he first came in, prior to the bail jump? I think there were an additional 4 days
Can you
there.
double check? He came in on booking date of December 23rd. And then, so in December, he had 8 days.
But prior to that, he came in.
Don't have that on the jail.
There was
laws.
a bail jump, but he failed to appear.
Let me just check the file real quick.
His first appearance was,
Before I was let on supervised release.
Oh, he was released when he came in.
the 1 day, or
So it looks like maybe less than a day.
there was an arrest, so he was put on supervised release, so it had to be this 1 day.
I believe it was the weekend.
Well, let me see here. Like booking date 12. Let me go back here a little bit. Okay, hold on. I got two days in October. Does that sound right? 2 days?
Well, he was saying 4, but 2 days is better than none.
It looks
so-
like, okay, going back in the reg, someone didn't enter October, but
Okay.
October, he was booked on the 25th at 2 in the morning. He was released on the 27th at 7 p.m. So that'd be 2 days total.
Okay, so that gets him to 40 days credit?
So that would actually, it's correct, that would be, I'm sorry, they did factor that in. Sorry, you guys, it's 8 days in December, 28 days in January.
36.
That's 36, plus the 2 in October
38.
is 38.
Okay, that's what they've got. Okay,
So,
I
not
appreciate
to
the
be
explanation,
confusing.
counsel, as does my client, thank you. It's unfortunate, Your Honor, it's kind of a sad tale. The underlying charges were very defensible. Matter of fact, they wound up being dismissed. Mr. Smith suffers from a drug addiction that he was in the throes of at the time. He went into treatment, he missed his court dates, he accepts responsibility, however, he's very frustrated by his own behavior, and he understands the consequences, and he has nobody to blame but himself. But I think if he stays clean and he uses all the skills that he's learned, that he'll do just fine.
Mr. Smith, do you wish to make a statement to the court before sentencing?
That's it.
Well, it is a interesting procedural path that the case is taken before the court. I'm not going to second guess the bargaining under the circumstances. The court will follow the recommendation. Yeah, I don't know what substance you're on, sir, but obviously makes people do things that they probably wouldn't do if they were thinking straight. So do you have a plan for what you're going to do and how you're going to?
Yeah, I was actually going to Lifeline, and I was supposed to go into inpatient the day of my
Yeah.
trial date. And they put me in custody instead.
And I know that part of the agreement was, the no contact with 5 years with Daniel J. Fisher, the victim. So that's not a separate order, that's just part of the JNS, but 5 years no contact with that victim.
You have no
Is
reason to contact
that appropriate under these circumstances when he's pleading to a bail jump? I guess.
Well, it's part of the same case it all arose from, and it looks like it was bargained for in the offer.
Seems to make sense. Any reason that doesn't make sense? I mean, it's not.
Other than it was agreed to, but I mean, he has no reason to have contact with this individual.
Okay, well, I'm going to sign the order. It just the fact that it's a bail jump plead, but I guess the court has to consider how we got to a bail jump.
I mean,
not
there's
just,
also cases where we dismiss the theft, but proceed on the drug charge, but
Right.
we still have the issue with the victim
All right.
with theft.
I'm satisfied it's probably appropriate. So there'll be no contact order, sir, with that gentleman. Is that somebody you knew or just a stranger?
Just met him.
Well, you're going to get out here pretty soon, but if you're looking at Lifeline or some other plan, you might want to get that lined up so you're ready to go right there.
Yep.
Thank you, Your Honor. Step over here.
In terms of ability to pay, are you working, Mr. Smith? Okay, I'm going to find that you're presently indigent but may have future ability to pay on the LFOs.
Mr. Dickinson.
last matter on the docket, number 11, Dickinson.
All right, are you Mr. Dickinson?
Yes.
Is this a plea on information as originally filed?
Yes,
It
Your
is.
Honor.
Okay, Mr. Dickinson, how old are you?
30,
How far did you get in school?
9th grade.
Do you read and write English?
Yes.
Were you able to read and go over and understand the guilty plea form with Mr. Weir's assistance?
Yeah.
Do you need any more time with him or have any questions of him in order to be comfortable going forward on this today?
No, I'm good.
Okay, you have the following rights: the right to a speedy and public jury trial, the right to remain silent, the right to hear and confront the state's witnesses against you, the right to call your own witnesses, even if that's at public expense, the right to the presumption of innocence, which means the state has to prove you guilty beyond reasonable doubt, and the right to appeal if you went to trial and were found guilty. Do you understand all those rights?
Yes.
You understand those are what you're giving up in order to plead guilty and get the benefit of whatever recommendation may have been bargained for here.
Yes.
Okay, if you're not an American citizen, a guilty plea can affect your status in this country now and in the future. Any time needed to cover those issues with Mr. Dickinson.
No, Your Honor.
If you're on probation, parole, or supervision for a different crime, a plea of guilty in this case can affect those cases. You could be required to pay costs, fees, fines, and assessments, including but not limited to drug fund contribution here. Because there's at least one felony, you'll have to give a DNA sample and be charged the collection cost of that. You'll be giving up your voting rights until and unless those are restored, as well as your rights to use, own, or possess any firearms unless and until you get those rights restored. And to the extent that you're incarcerated, you won't be eligible for public assistance while you're behind bars. Do you understand all that?
Yes.
So the charge here, possession of controlled substance methamphetamine, that's a Class C felony under Washington law. Is there agreement as to 7 points of criminal history?
That's correct.
That's correct, Your Honor.
All right, that means, sir, that on this charge, the standard range is 12 to 24 months, with 12 months community custody, maximum term 5 years, maximum fine $10,000. Do you understand that's what you're potentially facing by pleading guilty on these charges?
Yes.
And even though there may be a sentencing recommendation that's been bargained for, that's only a recommendation. The court gets the last word, and I can go above or below what's being recommended as long as I have the legal authority. You understand that? So there's no guarantee of what your sentence is going to be.
Understand.
Okay, other than that sentencing recommendation, has anybody promised you anything or threatened you in any way to get you to plead guilty?
No.
How then do you plead to this charge?
Guilty.
And you gave a statement in your guilty plea statement that says, in Clark County, Washington, on January 9, 2015, you admit to unlawfully possessing the controlled substance methamphetamine. Is that your statement, sir?
Yes, it
Is
is.
it factually accurate and correct? Okay, we'll accept the guilty plea then, state's recommendation.
Your Honor, he's given a day of prison for 166 days. He has 19 days credit. Remaining time would be served DOC custody and 12 months community custody, standard fines, fees, and costs. Due to his history, would be a drug fund of $2,000 and lab fee of $100. That is all.
Somewhat straightforward, Your Honor. Not a great deal of drugs that were involved. Mr. Dickinson stepped up to the plate pretty much upon having an opportunity to review the reports and is in court fairly shortly after his having been filed on. Again, this is a young man who's indicates that he's been diagnosed as a paranoid schizophrenic, so he's had a tough go of it. Certainly usage of street drugs is not a resolution to mental health issues, but in terms of his capability of working, he can perhaps address that in terms of what his work history has been. I think that going to prison for a year and a day under the circumstances is sufficient in terms of punishment. He is going to be on probation for a 12-month period. We'd ask for some relief on the financials.
Mr. Dickinson, any statement you wish to make to the court before sentencing?
I'm in the process of getting on my Social Security right now. I have been for a little while. I put on Zyprexa and clozapam in the past. And I was in the process, I think tomorrow I start a new medication for auditory hallucinations and I hear voices. Other than that, I don't really have anything.
Do you have any sort of plan to solve the street drug problem? Do you have some help that you can reach out to or have any sort of plan for dealing with that?
I do. I I was in outpatient treatment before when all this happened, but
Yeah.
I wasn't doing what I was supposed to, of course. I don't really. I plan on, when my time's done, is going to inpatient and in Spokane.
All right. Well, yeah, it never fails to amaze me with your 7 points. 12 months is the low end. It's kind of an eye opener from my standpoint, but that's what the law sets forth. So I'm going to follow the recommendation: 12 months and a day. I'm hoping that you can. Sounds like you're dealing with a few issues, but if you can get your medication stabilized and then some treatment on the street drugs. But boy, you keep racking up charges like this. It's a real heavy price to pay, isn't it? It's a lot.
It is, but I think actually I probably need this right now. Go to prison.
I'm hopeful that it's an opportunity. I know it's a significant sentence, but I'm hopeful it's also an opportunity for you to figure out where you need to get to, right? In terms of the legal financial obligations, I'm going to say that he's indigent and not anticipated to have ability to pay in the future. If you do start working or are gainfully employed, you'll have to be in touch and get on some payment plan to work these off and pay them off. You understand? You'll get some instructions on that over here.
That's what the blue sheet is about.
Your Honor, there's a memo that one of our staff has brought over indicated, you'll probably know what it is. It looks like it was from something this morning.
Right.
We were just going to get a
But
signature from
Back on Dickinson, I am finding him presently indigent, but I'm also going to strike the fine and the court-appointed attorney fee in the judgment sentence as well. Correct, this is on Littlefield. There was some confusion on the bail amount on 2 different cases. There was a little bit of disruptive activity, so I think we got it ironed out.
Thank
With a
you.
clean
That should be
memo.
the end of our docket, and I'll get a copy to our office.
Thank you.